Thank you for joining us, everyone, today for our webinar, Tax Saving Power Moves with Charitable Remainder Trusts and Charitable Lead Trusts in the 2026 era. Slide. I'm John Olson. I'm the president of Life Insurance Trust Company, and very happy to have with me Andy Gregory. Andy is the founder and owner of Gregory Law PLLC and is an estate planning and administration attorney who graduated from the Mitchell Hamline School of Law in St. Paul, Minnesota. His practice focuses on helping individuals, couples, and families navigate probate, conservatorships, and general estate planning with a particular emphasis on sophisticated charitable remainder trust and charitable lead trust planning for high net worth clients. Active in the legal community, Andy serves as the governing council member of the Minnesota State Bar Association Probate and Trust Law section and is recognized as a North Star lawyer for his extensive pro bono work. Licensed in Minnesota and North Carolina, he lives in Minneapolis with his wife, Jessica, and enjoys running and bike riding in his free time. Thank you, Andy, for being with us today. Slide, we have a few administrative notes here as well. We do have a brief post-event survey following it. We would appreciate very much if you would complete. You'll get an email in 24 hours with a link to the recorded event, and if you need a certificate of completion, one would be available too. For the ABA website, search main character energy to enter your CTFA continuing ed credits there. And a link to a YouTube video of the webinar will be sent following. Slide, please. All right. With that, Andy, I'll happy to have you with us again, and we'll turn it over to you.
Great, John. Thank you so much. And thanks for having me. Really appreciate it. And yeah, so like as John was saying, I am an estate planning lawyer in outside of Minneapolis, and we are here today to talk about some charitable planning. And so this is kind of our agenda for our webinar today, and we're going to go through a bunch of stuff and spend probably about 45, maybe 50 minutes, talking a little bit just about some of the content, and then of course I like interaction, so I want to make sure we get some questions asked. And of course, John and the team is going to help kind of facilitate that as well. And of course, we're going to have some case studies kind of near the end. But what I always find fascinating on kind of charitable planning is just some of the things that just a lot of people don't kind of realize. As in my role at my firm, I'm in front of a lot of advisors, financial advisors, wealth advisors. Actually had coffee this morning with one. And it is, kind of fascinating to know, some of the things that they're not necessarily keenly aware of, because they're working with clients often on some of their financials, as you can imagine. And so, I sometimes get those questions a little bit later, kind of down the stream, when I wish I would have maybe got it a little bit more upstream. And so I think I always like the education piece of this. So whenever I'm having a chance to talk with somebody or share, I'm always kind of, I like charitable planning. I think it's important. It's important in my life, and I like to kind of share that with my clients, and especially ones that come to me with things that they have questions on. So really what we're going to do kind of starting, spend a few minutes kind of in each area is really kind of, I called it the strategic landscape of, really why we're doing this. And I'll apologize in advance. I do this when I kind of speak about this topic there's a lot of numbers. So hopefully the lawyers didn't just, click off of the webinar when I mentioned that. But, there is a lot of specificity and nuance in these. And I would say kind of at the outset, you'll probably hear me say this throughout the presentation, is having a really good CPA that knows and has a lot of knowledge based on this specific type of strategy and planning is really key. This is not just kind of your regular man or regular woman's tax planning. So really important. These are very structured kind of things, and include a lot of kind of heavy items. So just, if there's always a chance, obviously people can reach out to me with questions if they ever did or needed some help. I do the same thing in my practice. I reach out to some trusted attorneys that I know really well in this space. So just wanted to kind of mention that. I'll mention it throughout the day as well. So, one of the things that means a lot to what we do is really interest rates. And when I say interest rates, this isn't probably what you're thinking of, kind of general interest rates that we read about or see on the news, but this is kind of our 75/20 rate, which is going to be a slide coming up here in a little bit. So really what that 75/20 rate is basically what the IRS kind of talks about when we are kind of looking at what values to place on these kind of items. And so, we have had kind of a very low, historically low, kind of environment regarding the 75/20 rate. And really, if you think about it, we are going to talk about, charitable remainder trust and charitable lead trust, so CRTs and CLTs. And they're kind of almost, the different sides of the spectrum, and kind of like a teeter-totter. And so, what it is that 75/20 rate really indicates what way we kind of go. If we have a high rate, then we are going to be doing more CRT planning. If we have a low rate, we're going to be doing more CLT planning. So right now, if you've been kind of tracking this, if you're in the space, earlier this year, starting January, we were at about 4.6. Here in August, are going to be, we're at 5.2. So you can kind of see where things have gone there, where maybe earlier this year, CLTs might have been the way to go because we can lock in that rate. Versus now where the rate is a little bit higher, where maybe CRTs is going to be the option that we choose. And so this is kind of that, we call it the hurdle rate, but this is really that idea of, okay, how do we get it? And you want to make sure, as I mentioned here on the slide, you can use the rate for the current month or the either of the two preceding months. So you always want to check all three when you're kind of looking at this. And there's some really great kind of tools. Some large firms will have them. One of them is called Number Cruncher, where it can run scenarios for clients regarding different types of setups, which we'll get to here in a little bit. And so what I wanted to kind of start with after looking at some of the 75/20 rate. I want to go back before we jump into the CRT, is what we need to do with clients is try to get them past, I call it kind of like checkbook giving. A lot of times people that are philanthropic, or they're very kind of connected to maybe their place of worship, or a veterans association, or maybe they've been impacted on a medical side, so they're very involved in maybe the Cancer Society or something like that. And what it is, it's really trying to say it's really great that you're writing a check every year, or you go to that event and you support that event, which is great. However, what this really needs to is kind of, what could we do that could actually benefit not only the charity that means a lot to you, or that nonprofit, but also benefit your family and also maybe your tax, situation based on, the complexity of the estate. And what we want to do is we want to try to minimize that. And so oftentimes when you're, talking with estate planning lawyers, we're always talking, especially in this realm, about estate taxes. Obviously, there's some people on the call that might be from Minnesota, some others from other states. Minnesota, we're a state estate tax state. And so when we're planning, we're having to navigate that. And so that's just one thing I wanted to mention. And then also something I wanted to mention is this is a really great idea and a really great way to plan for business owners. And the reason why I talk a little bit about that is, capital gains on assets is huge. That's what you hear all the time. You talk about, some type of business owner, whether they have a warehouse or they have a building as part of the sale. Hey, we bought this, Andy, in 1995. The building was worth, $500,000. And now the building has, gotten this large kind of increase. That's something to really kind of maybe talk about, because there are some really great ways that we could help mitigate some of the capital gains, especially on, we're going to get some case studies here in a little bit, especially on some of the business owner side. So just wanted to kind of mention that before we get into some of of the weeds regarding some of the topics. So, charitable remainder trusts, and like I said, retain income while securing massive capital gains deferral. So, when we talk about those CRTs, we want to, kind of fundamentally kind of outline what this looks like. So, this is a presentation that has a lot of acronyms. I'll apologize in advance. But as everyone can see, we have our CRAT and we have our CRUT. So, a CRAT is obviously a charitable remainder annuity trust. So, this is a annuity that you can formulate, and it pays a fixed dollar amount regardless of market performance. And really, what this means is we need to run a kind of a numbers regarding how we set this up. And this is one of those things where um, you can't add additional contributions to it. So that's one thing to kind of think about. If it's one where maybe it's a stock situation, we got some stock that was inherited, or maybe they have a very low basis stock and they wanted to kind of work that into this CRAT where it paid this fixed annuity amount, which I'll get to why this is so great. Um, but then next year, maybe the stock they get some additional stock. Well, they can't add it to the CRAT that they've already done. There needs to be a new one opened up. So that's one of the kind of the downsides, I should say. Often as well is younger folks, like I mentioned, they don't pass something called the 5% probability test. And so obviously you can see there the Rev ruling that talks a little bit about there has to be the principal can't run out. So what that basically means is there must be less than a 5% chance that the trust runs out of principal before the charity gets the remainder. So what that means is that annuity pays out. Uh, and then, of course, whenever that period of time is exhausted, there's got to be at least must be less than a 5% chance that the charity receives the remainder. So what happens is that person passes away. Whatever's left in that annuity then obviously goes to the charity. Um, Now, the other option is something called a CRUT, or we call it a unitrust. And what this does is it pays a fixed percentage, minimum that 5%, of assets that are revalued annually. So this is really just a little bit different on where things are. And I want to get to my notes kind of about that section.
And Andy, I'd like to announce too that if anyone does have questions, they can put them into the Q&A, and I'll go through those and we'll answer as many as we can. But that is where we will take questions and address them as they come in. Or
Great.
we have some time
Great.
at the end as well.
Awesome. Thanks, John. And so I wanted to kind of just right before we get into that unit trust, is really kind of just an example of like a CRAT is if we have, let's just for example, let's say we have like a 65-year-old client and we have a low 75/20 rate. And we remember if it's low, a CLT might be the option. Um, that CRAT is going to probably fail. And the reason why is because of that probability test. And so that's something to really to really think about. So going into the unit trust, I want to talk a little bit about what that looks like. And so this doesn't have a 5%, but it has a 10% remainder trust. So what that means, and I want to kind of spell it out, is that, and there's an IRC section 664D2 capital D, requires that the present value of the charitable remainder in the unit trust must be at least 10% of the value of the assets contributed. This prevents, really, it prevents the donor by getting a very, very large payout for, let's say, a like 20-year-old child. And so really what we want to do is kind of take those in consideration. So when we talk about CRTs, we have a CRAT, that CRT, that annuity, that charitable remainder annuity trust. And then we also kind of have as, really a different option that kind of is structured a little bit the same, but a little bit differently is our CRUT. And so I wanted to kind of outline a little bit of some of the, again, more intricacies within that charitable remainder unit trust. So there are two options, as you can see. One, which is probably one where this is something that's very important when we are talking a little bit about kind of retirement. And what this does is it basically says, okay, we have either our unit trust percentage, which is that kind of that annuitized kind of item, or our net income. And what it basically indicates is, and this is where our CPA kind of comes into play, is if there is any deficit, um, we can kind of make up that deficit down the road. And so this is like it indicates, this is perfect for a zero dividend growth stock. So a lot of times I had a conversation yesterday with a client who says, I have this very, very large, let's call it a non-qualified brokerage account that holds, I think she indicated maybe about 6 or 7 stocks that she actually inherited from someone else, I believe a parent, and they have a very, very low basis. And also, they aren't really doing many kind of dividends. So we were talking a little bit about options, and this is, like I said, always these are options. This isn't for everybody. But I think it's one of those things where I love to have those conversations with people just to kind of get them thinking about what this could look like. So again, that's called our really our NIMCRUT, net income with makeup is what that stands for, if you're keeping track. Then we have our flip CRUT. And so here's kind of the scenario that I want to kind of give you is, let's say we have a client and they have we'll call it $5 million office building, and they want to do some type of unit trust. Um, but that building, it really produces zero income. There is no income. It's just an actual item. So what they do, or the solution here, is it starts kind of up top as that NIMCRUT, and it really pays zero because that, remember, it says pays the lesser of the unit trust percentage or net income. So we start to pay zero, and then it flips to a standard CRUT upon a triggering event. And the triggering event would be like a sale of this illiquid office building. And there are some rules around there. It's got to occur on January 1st of the year after the sale. So that's something that has to happen. So really what that means is that you are putting this item into this CRUT. It is paying really zero, because there is no income. And then there is a sale, and whatever that sale comes for, I don't want to have those numbers right in front of me. Um, we then flip it. And how that works is whenever we flip it that next year, we now can save really on some of the kind of income tax, or really capital gains. And this right here is a little bit of some, again, more numbers. And there are some deductions regarding different types of things. So you can kind of see here, we have our rules. We have our asset type on the left. And of course, if we're given to a public charity or to a private foundation based on what these are. So really what this means is, for example, let's say we were going to give cash to a public charity. Um, or maybe let's go back to our example of the $5 million property. Appreciate capital gain on the property. So if we're taking a 30% income tax deduction based on the AGI, if we're handling it that way. So it is, as you can see here, really beneficial for certain folks, based on again, based on the situation. This isn't really for everybody, but it really allows people to get a different kind of view of what they could offer based on this. And one thing to kind of remember, I mentioned it kind of at the bottom of the slide, that for CRTs, so charitable remainder trusts, the deduction is generally based on the fair market value held on, fair market capital gain value on that property held over a year. So we have to get, appraisals. There's a lot of kind of things involved in CRT planning. So again, as a little bit of a review, CRT planning, when that 75/20 rate is high, we're getting creeping up there. I said earlier, January we're at 4.6, now we're at 5.2. So this might come into play now while those rates are a little bit high. And so you'd want to run those numbers based on the situation that you have. And again, some firms, some organizations have some programs that can really do that for you. So we talked a little bit about CRTs. Let's kind of transition a bit over to charitable lead trusts. So what we do is we invert the strategy to pass massive appreciation. And people like to see the words tax-free. So let's kind of talk a little bit about what that looks like. So again, like I mentioned, there are the same options. So we have our lead trust versus our charitable remainder trust. And within that, we have something called a CLAT and a CLUT. And more than likely, you're probably hearing CLAT a little bit more on this side of the house versus the others, as you can see. So really what this is best for a state tax freezing. So if the growth of that annuity outperforms that rate we talked about, that interest rate, the excess then, so for example, if the assets grow, let's say at 10%, and the 75/20 rate is at 4%, then guess what we did is we are just now passing that 6% growth tax free onto our heirs. And really, and that is probably one of the most important reasons why people like CLATs is they can utilize this tool and wipe off those gains. And that's where, again, we want to look at that 75/20 rule, figure out if it's low, that's why we want it, because more than likely it's going to be outperformed. It's going to be outperformed by the asset, and we're going to be able to pass that over. So again, a little bit less common is that charitable lead unit trust. And this goes like it's talked about, usually used when the donor wants to provide a variable gift to show charity that shows, or I'm sorry, that grows with inflation. So not that common. People, obviously do utilize them, but they're just not something that I'm even kind of familiar, handling. They just don't really have much kind of runway. So let's talk a little bit about kind of those CLTs. And this slide talks about grantor and non-grantor status. But what I want to do is talk a little bit about something I call, or what is called kind of a zero it out CLAT, or sometimes they're called a super GRAP. Again, I apologize for all the acronyms, but this is that type of kind of webinar. So you knew what you're kind of getting into. So really what this zeroed out CLAT is for is it structures payments to charity so that mathematical value of the remainder going to the kids is exactly zero. So what we normally like to do is we'll back load an annuity. So what that means is there's there's a kind of, we call it a shark fin. It's very low payment at the beginning, and it's a massive payment in that last year. And really, those last years are determined by a lot of clients. So there are charts that this is something where it's a great idea to have client, wealth advisor, estate planning attorney, CPA on these calls to kind of walk through what this looks like. I call it whiteboard, really get something up there and actually look at the numbers. And this is actually where the numbers matter a lot and really the goal of the client, where we want things to go. So what that means is like in the shark fin kind of CLAT, is that growth, we keep that principal in the trust longer so we can maximize the compounding growth for the family later. So I wanted to mention that. It's not on the slide, but that was something I thought was really important. But so moving over to this grantor non-grantor strategy. So on the grantor CLT, you can see there is a 100% upfront deduction. So that grantor who is starting this, they receive an immediate massive income tax deduction right away. However, there's a catch, there always is. The donor is then personally taxed on all the trust income for the life of the trust. So that is the flip, and really the strategy for this is, let's say for some reason you have a client that has an immediate spike in income, whether maybe it's a sale of a business or some other type of event, they have a spike, but then it's going to whittle, it's going to go back down. And what this really means is let's do the deduction now when we hit the spike, which would make sense. Let's take as much advantage as we can of that upfront deduction. And yeah, we have to pay income tax on that rest of the life of the trust. However, if you're in a really low bracket, that's a no-brainer. Now, on the flip side of that, we have that non-grantor CLT, and theirs a little bit different. So they receive no income tax deduction up front. However, that trust is its own taxpayer and receives an unlimited charitable deduction. And there's a IRC 642C. So what that strategy is for, that is probably for more of the high net worth client, where we're worried about the long term. And what they've already hit is probably their 60% possible AGI charitable limit. So we talked about that a few slides ago. So that is the limit obviously put on by the IRS. So you can't go above that. Well, what do we want to go above that? Well, then we have a tool like this where we can utilize this, and really it allows them, I don't want to use this word, probably the slide does, but cleanse some of that income before it hits the 1040. So just a little bit of a different scenario based on if you have somebody who is they're already giving, they're hitting like that AGI number, and then they're also wanting to give more, but also try to help a little bit on some of the tax issues versus somebody who, let's say, has a one-time spike, let's call it $1 million or maybe 2 million, then that's going to go back down. Then we probably want to go more on the grantor side and that strategy. So we talked a little bit about kind of obviously, CRTs, and kind of the fundamentals behind those, all of the different options, the CRAT and the CRUT. And then we moved a little bit to our charitable lead trusts, and really some of the things regarding CLATs and CLUTs, and then also some of the grantor versus non-grantor options. So what I want to talk a little bit about is some of the, maybe some compliance and pitfalls, like I mentioned. And this is probably a good time to, kind of sit here for a minute. I said at the outset that this type of planning really should be done, not kind of in a vacuum. I believe, having somebody that really understands what these things look like, have experience on utilizing them. And I want to say people, I mean a good person on the CPA side. And I know someone that I know pretty well here in the Minneapolis area, that does a lot of this type of planning with clients. But I'm sure there's other folks as well. So that's something to just kind of make sure you kind of keep in the back of your head, because this is something that's very, as you can see, a lot of detail, and a lot of projections. And I kind of mentioned some of the programs. They're great. They are very user friendly, like kind of like Number Cruncher, where you can see, okay, let's do option A. What if we do this? Well, let's compare that with option B. And what happens if we do this? And if we have, obviously some attorneys on the line, some other estate planning, every single person is a little bit different and they all have a different goal, maybe different needs. Maybe they haven't even thought about some of the charitable giving they possibly could do. But when they actually can look down and kind of sit back and go, wow, I didn't know, Andy, that I could do something like this. And, number one, they care about their charity. They're passionate about something like that. They also love their family. They want to make sure they're taken care of. And then also they don't want to pay more taxes than they need to, on obviously more on the income side than on the estate tax side. So that's something to kind of keep in mind when you are, maybe even reviewing this later, or talking to somebody. So again, a couple things to kind of think about on, different type of, I should say, traps. You want to make sure you avoid these type of things. First is just, qualified appraisers. So that's something that's very, very important. Um, and that really is the number one reason why these deductions fail, because they can be challenged. So just like, that awful word of an audit, things like this can come sideways to you. So obviously, any non-cash gift over $5,000 requires an appraisal or something called a qualified appraiser. That is, a official form 8283, cannot be done by a non-professional. So that's very, very important. Also, timing on those are very, very strict. The timing on qualified appraisers no earlier than 60 days before the gift, and no later than the tax return deadline. So you can't have an appraiser that was done in 2023 if we're making a gift in 2026. So that's very, very important. And again, CMAs or CPAs are not sufficient. So I want to repeat that. CMAs, or the real estate agent CMA, or the CPA estimate is not a qualified appraiser. So be very, very careful on that. Also, there is no really self-dealing. So even if the deal is, let's say, good for the trust, there is no fair market value exemption. So really, really important. Another thing to kind of think about, and a lot of times people kind of forget this, the donor can't live in a house that's owned by the CRT. So, or they can't lease office space if it's held in a CLT. So again, CRT, if you're living in a house that's in a charitable remainder trust, can't do that. It's a no-no. And of course, leased office space on the CLT side. And also, there are some kind of, I'll call them disqualified persons. Those are donor spouse, ancestors, children, and grandchildren. So be very, very careful when we're talking about things going between family members. You can get yourself, or maybe even your client, in a little bit of a legal term I like to use, a pickle. So also, one thing to kind of think about, the IRS has very good procedures. They are kind of very vanilla. So one thing to always think about whenever you're kind of maybe drafting these is watch out for like investment powers of the trustee. So be very careful. I said it here, always customize for family dynamics and corporate fiduciaries, really, really important on, when we talk about trustees and what they can do. Uh, one of the things also to not kind of forget about is S Corp stock. So very clear. And I know there's a lot of kind of business owners. Obviously, there are S Corp stock. CRTs cannot hold it. And doing so, again, kills that CRT's tax exempt status immediately. So be very, very careful on how you handle that. And I kind of have a tip here. Use a CLT in that situation or convert to the C Corp. So just be very very careful when you're talking about what type of item is in one of these things, making sure that we're not running afoul of really the rules. So what I'd say is just be careful with these kind of items because they're definitely not kind of um, run the mill type of things. So again, talked a little bit about the self-dealing 4941. You can't do that. Like I said, even though it's a good deal for the trust, be very, very careful on fair market value and things like that. So again, just there if I always say if it kind of sounds too good to be true during this process, or if a client asks you, well, oh well, I'll just put my house into the just be very cautious and make sure you're doing some research, especially in some of the RSC guidelines. So I'd like to kind of go through also, we talked a little bit about the process, these different tools, some of the things to kind of look out for. Now let's maybe look at some case studies. And I know last time I did this presentation, I was with a friend of mine, and he had some great stories. I wish I had the same stories, but we'll use the ones. These are closely aligned to some kind of real life scenarios. So we'll use some of these to kind of talk through. And of course, ask any questions that might pop up. And we want to make sure that we have enough time if there's questions kind of near the tail end of this. So first is and I think I mentioned this earlier in the presentation about capital gains. So here we have let's kind of put the scenario out there. So we have a client who has a closely held business. And let's call it that business is worth $2 million. And that business has zero basis. So low basis, pretty big capital gains, and obviously depending on the state type of taxes. So right off the top, it's a $400,000 capital gains bill. So you're looking at someone losing close to 25% of the value based on this sale. Okay, well, what really are maybe some options that we can look at? So again, high rates, maybe a CRT. We're at a high rate. We're in August, so it's going to be 5.2. And we talked a little bit earlier about, different options on charitable remainder trust. So here, well, what about if we moved the shares to a CRUT right now? So what that means is we are going to basically the CRUT's going to sell for that $2 million sale, and we are going to pay zero tax. And what's going to happen is that $2 million that we received for our business sale, that is going to be really reinvested. And it's going to pay like a fixed percentage, like I talked about, every year for, annually based on, kind of a calculation. I don't have time to kind of have everything up right now. But what we do is we kind of look at that number. Of course, let's call it a 5% payout. And we have a $2 million deal. That's $100,000. Instead of that money being invested, and we're getting a 5% return on a $1.6 million. So did our math. We took 2 million, we minus that $400,000 capital gains. We only got 1.6. We're getting that same payout. We're losing about $20,000 if we do the CRUT. And what happens is that difference between the 5% payout and that difference between the 80 and the 100K results in that 25% permanent income boost. And so that is a really great idea for somebody, like I said, that's in that maybe closely held business kind of way. And it can really help benefit a lot of people in that situation.
Had a
So,
question, Andy, if you have a
sure.
moment
Yeah.
on this. Actually, a couple. The first question was, does the $2 million go against the lifetime gifting exemption?
The $2 million, and we're talking about the $2 million that is going into
The CRUT.
the CRUT. That is, and I know I want to make sure of this. Um, so really, this technically, if you think about it, really isn't a gift. Like it's a gift from one person to the other. This is something that really is going into some type of immediate kind of charitable realm, and it's kind of locked in there. So it's not going to go against kind of our lifetime exemption.
The second question is, the CRUT leaves a minimum 10% at the end. Is that correct?
Minimum 10% at the end. I want to make sure I look at my notes here. Yeah, so 664 indicates that yes, there has to be that 10% remainder. And that 10% is what is, of course, is going out to the charity. So yeah, so there has to be, it requires the present value of that remainder interest needs to be at least 10% of the value of the assets contributed. So yes. Yeah, good question.
Okay, thank you. I'll just interrupt you as they come in.
Yeah, great, great, great. As everyone is hearing, this is numbers. This is a little bit different kind of planning, but I think really important. And of course, I have a few scenarios here in our slides. It's not going to cover every single option and every single scenario, but at least it'll give you some things to be thinking about. And I really love to just get people thinking about these type of things. So let's look a little bit at our next kind of case. So everybody on the call is probably very familiar with the Secure Act. And this is probably where I want to kind of sit for a little bit. So we all know, or hopefully most of us know, that people have a lot of qualified assets. And one of the biggest, obviously, are just traditional IRAs. And we all know that with a traditional IRA, if that item then, of course, passes to spouses, unless there's a difference of, large gap in age, there is obviously a stretch. But what happens when that goes to children? And that is a problem because not only do they not have the stretch, they have to take that money out within 10 years. And as you can imagine, they have their own taxable income. And so you're saying, okay, I got this, and now I'm layering on top different types of, and they're receiving these massive tax spikes. And so this is probably one of the most, I think if anyone was leaving with something, I think this would be a good one to kind of leave with, is to kind of look at this a little bit. So what we do is, as the slide indicates, we name a CRUT as the IRA beneficiary. So we have our beneficiary. A lot of times planners will utilize this on like RMDs. Will go to charities because it's a pure tax deduction. Because sometimes people are taking RMDs and they don't really need the money, but they are mandatory, have to take it. But then also they'll leave, they'll make one of these qualified accounts. The beneficiary will be a charity. Now that's a little bit different than what we're talking about here, and there's different reasons why you do each of those, and we don't have time to sit down with that right now. But what that does is that IRA, that person passes away. those proceeds fall into that tax-exempt CRUT. So it was zero tax at death. And how we build out that CRUT, if we're remembering back, a few slides ago, is it pays a fixed percentage for life. So that is to that child. So whatever is in there. So what did I say earlier? I said, hey, if you have an IRA qualified account and you leave it to a child, a son, a daughter, or multiple kids, they only have 10 years to take the money out. So, for example, let's say, dad passes away. He's got a $300,000 IRA being split between three children. Well, now I need to take, $100,000 out within 10 years. Now, let's say that wasn't $300,000. Let's say it was $3 million. So you can kind of see it. It really hurts that child. Well, if we can do something like this, where they are going to be the beneficiary of this CRUT, not a beneficiary like the slide indicates, the IRA is the beneficiary, but we annuitize that money to where now those kids are receiving, 5% of that value for life. And that is a really interesting thing to think about, because now they're not, it's really, like it says, it's resurrected the stretch through this charitable vehicle. So again, this is probably one where I like tell people this is a great place to kind of to go back, maybe if you're reviewing some of the notes, to look at this one. So it's really, really important.
A couple more questions, Andy, and
Yeah,
I think from the last slide, they asked, is this is not for an S corp, correct?
correct. Be careful about the S corp and the tax holdings. Yes, correct.
And the second question is, what size of an IRA makes charitable stretch cost effective due to the increased administration expense of the CRUT?
Ooh, great question. I was waiting for someone to ask that one. And that's a tough, and that's something obviously we didn't talk about, is fees. These things they're expensive, and that's something that everyone I think weighs based on the situation. But man, I don't know if
Mhm.
there's a good way. It all is just so specific based on the goals of the client. I wish I had like a bellwether. I would probably say in my example, if I had someone who had a $300,000 IRA and had, let's say, two children, and said, "Hey, is there any way that I could, really not hurt them by getting this money?" And wouldn't I'd say by the time we spend all this money on this item, walk through this, I don't think your kids. I don't really think they'd be that concerned. Now, if that number is 3 million or six, and it's the same two kids, that's a lot different of a situation where you know dissolving $3 million in 10 years. That's a $300,000 a year hit.
Mhm.
I mean, that's a huge amount of tax. So I guess it's just one of those things where it differs based on the situation.
Yeah, that's going to be kind of specific to the client as well. And to go back to the estate, the lifetime gift exemption thing, my understanding has always been that if it was, like a self, like the donor donated that, there's no gift because the actuarial remainder interest is going to charity and the income interest is staying with the person, so there's not a gift. However, if it went to a third party, the actuarial value of that income interest would probably be accounted against a lifetime exclusion. Does that sound correct to you?
Yeah, I mean, it could be. I have to dig into some of the IRS kind of stat rules.
Hmm.
I think you'd have to look at, yeah, I mean, there could be a little bit of an exposure there. But I think um, and really, I- yes, I think, John, I think that's a good way
Yeah.
to look at it. I mean, you just have to you just kind of crunch the numbers just to make sure exactly how that would work.
But it's not the $2 million that's the number that you'd be concerned with. It'd be the
Correct.
actuarial value of the income interest if that was going to a third party.
Yes.
And
Yes.
so uh we just had another one come in. It's a little bit longer. How frequently do we see these vehicles being in net positive in terms of overall financial gain to the donor, specifically if they are unconcerned with charity and just want to maximize dollars in their pocket?
Read it again, John.
How frequently do we see these vehicles being net positive in terms of overall financial gain to the donor, specifically if they are unconcerned with charity and just want to maximize dollars in their pocket?
I mean, I think it's an option you give people.
Mhm,
There's other, we all know whenever you're in this realm and you're talking about high net worth clients or people that are just, kind of tax avoid, there's the control piece. That's the
mhm,
biggest piece of this when we're talking about ILETs. There we go, John.
mhm,
Perfect example. You're giving up control, and they're great tools. And they're great tools for a lot of people. And John could have his, whole hour talking
mhm,
about the impact that ILETs can make. Um, and that's the same kind of conversation I think that, I have as a practitioner when I talk to clients about these different options. There's a slat is something we're looking at. Would an eyelet be how we handle this? I had a client call this morning about an eyelet back
mhm.
and forth. Um, and this is another one of those where it has to, it wants to fit. And you're exactly right. I think the person asking the question, it's something to run through the options. Hey, Mr. Smith, Mrs. Smith, I understand that you didn't really mention a passion for, XYZ charity. However, this is something if you have, something in your life that maybe is an option for you, this is something that we could do. And it allows just to hear what the options are, I think, um, for people. But
And-
it's not a perfect system or a perfect fit maybe for everybody.
Well, and I think it would also depend on how highly appreciated the asset is. One $2 million contribution that's maybe only one quarter gain versus one that's three quarters gain. It's a different number based on that scenario, I would assume.
Yes, and that's really why that CPA brain is I mean, they're running, and that's where those number cruncher programs come in. John, you're exactly right. It's so specific. I mean, I mentioned this when I had this presentation, especially when I did it last month. Very, very specific. I can't, we're using scenarios to keep it light because it's a webinar, but these are things that you really want to make sure you kind of do your work on. So I wanted to kind of, go through a couple more scenarios. I know we have just a couple minutes left. So case three, really just an ag kind of flip. We might have some folks in other parts of the country that don't have as much cement as where I live. And we have a farmer. We got a 100, 1.5 million in land, small, super low basis. However, they want some gains, but they don't obviously, I'm sorry, they want some income, but they don't want the gain. So we talked a little bit about that flip CRUT option in the past. Remember the example was that $5 million building that produces zero income. And so here we kind of do the same thing. The land produces zero income while listed in that NIMCRUT phase, that first part. And then once we sell it, if you remember, we got to do that flip on the first day of January after the sale. And then guess what happens after that flip? Bypasses the gain, receives a lifetime income stream based on the $1.5 million price. So again, some really cool ways, especially for maybe different folks that they had no idea. I don't want to say guarantee you because I'm a lawyer. I don't like to use the word guarantee, but I could say with a lot of assurance, you tell a farmer or you tell someone in this situation, yeah, they might not be philanthropic, but you let them know that there is no gain, uh, and they can get lifetime income. They might be listening to you. So I think really, really important. Um, One of the last here before we kind of wrap up with some Q&A, and thank you everybody for the questions during the presentation. I think they're great. Hopefully people found them helpful. So here what we have is kind of wealth transfer. So this is probably somebody, high net worth. We have parents that have a $10 million portfolio of growth stocks. They want to pass it to their grandkids. Obviously, we have now a very, very low 75/20. And so we're looking on that really CLT route. So that's where your brain kind of goes. What we do is we go back to our grantor, non-grantor. If we remember in our presentation a little bit earlier, grantor receive, that's a spike. If you remember, if you have a spike, use the grantor. Non-grantor CLT is a little bit different. That's where we don't get an income tax deduction right away, but we can we can that really we can cleanse it before it hits the 1040. So just we'll follow along on the slide. We have our portfolio. And what this means is we establish a 20-year CLAT, non-grantor, with a 5% annuity to the family. This is the family foundation. So again, we're talking about ultra high net worth. So they're creating foundations for tax purposes. And if you think about it, let's just assume 4% hurdle rate, but 8% return. So now what happens is that foundation annually is going to get $500,000. So that's the 5% of the portfolio. So $500,000 supporting the family's kind of philanthropic endeavors. 20 years go by. That original 10 million that we put in there, access the growth, because we can access that, it's grown, is now passes to the children, little or no gift tax. As the gift, going back, John, to your question, the gift was valued at that 4% hurdle. So remember we said it, we lock that in when it's low, and that's that gift. So 4% of the value is technically a gift. However, all those gains move tax-free. So again, a really cool idea. Take a look at this one as well. I think all four of these case scenarios are really good. I think I especially like this one and the stretch one, because I think there are some ideas to kind of to get everyone thinking on some of these things. So we're wrapping up, and I want to go long. So questions for
I have
anybody.
some. I have some for you. So this is a kind of part two of one of the last questions is, with AGI's tax deduction amount being different for charitable destination of remainders, public charity versus private foundation, and CRUTs allowing for a change to the charitable beneficiary, how does changing the beneficiary down the road affect previously used tax benefits? Is the type of beneficiary irrevocable even when the specific beneficiary may be able to be changed?
Ooh, John, repeat that one for me. That was a long question.
Okay, yeah, it was. With AGI's tax deduction amount being different for charitable destination of remainders, public charity versus private foundation, and CRUTs allowing for a change to the charitable beneficiary, how does changing the beneficiary down the road affect previously used tax benefits? Is the type of beneficiary irrevocable even when the specific beneficiary may be able to be changed?
Mm,
So I think, if
that's
you have a public charity versus a private foundation, can you change that midstream?
yeah, that is I always like to go to some of the IRC rules. So I think the answer would be if and we're talking here, the remainder interest is the charity.
Mhm.
Um, I believe a lot of times people use like donor advised funds, so we don't have to actually rewrite the trust because of the options. Um, However, if it's in that kind of irrevocable status, which some of these are, you can't change that income recipient. So I think I want to do a little bit more digging in some of the rules before kind of giving a solid answer. But I think I'll be all out, at the outset. If we have the charitable remainder beneficiary oftentimes can get around that with DAFs. That's something that people do. But it's, and I guess it also kind of determines on how that original trust was written. I really would want to see what that looks like, to see if that's something that we can do, or if it's something that we'd have to update the trust to make sure we can do.
All right. Another one here. How can you pass a CRUT 10% remainder test from an IRA death distribution when the date of the distribution or amount are not known? Is the CRUT drafted at death instead of before?
Repeat it, John.
How can you pass a CRUT 10% remainder test from an IRA death distribution when the date of the distribution or the amount of the distribution are not known. Is the CRUT drafted at death instead of before?
No, it's always drafted before. Um,
Mhm.
and I think uh, that's where those tools will come into play because it's going to run some scenarios to make sure that we can pass the 10% test. And that is, I think, really important, especially based on how old the kids are, how many lifetimes. There's a lot of different parts of this
Mhm.
um, that I wish we had time to kind of
Yeah.
discuss, but we just don't.
And a couple comments. There's a software is critical runs to scenarios. The gain is not eliminated, but spread throughout the tier system.
Hmm.
Um,
Yep, exactly.
then is there a minimum time an asset must remain in a CRUT before it can be flipped?
Um, Not necessarily because it only flips due to an action. An action like a sale, those type of things. This has to be flipped the first day of the next year following the sale or some type of event.
And I had a comment on the question about the charities and foundations versus a public charity. Says the document states who is eligible charity, and if a potential charity may be a foundation, the lower AGI rule applies even if a public charity is named later. So thank you
Okay,
for that
thank
input.
you. Yeah, great. This is it takes a village to sometimes
Mhm.
get through the webinars. I like I said, I have a good friend of mine that I reach out to and run some things by her as well. And I think we're always better when we can kind of put our minds because people see different things, they've experienced different cases, have different strengths. So yeah, thank you for who kind of put the the question out there. So, John, I think we're at our time. And I'm
Yes, we
sure
are.
you are wrapping up. I'll stop sharing.
Well, I appreciate your time and your comments about capital gains. I've always thought capital gains was kind of the most unfair tax because it's kind of a tax on inflation. I've known people with highly appreciated real estate, bought rental properties in the 60s and 70s for a song and a dance, fully depreciated the improvements. So they had a real estate that had gone up in value, but basically at the rate of inflation. If they were to adjust it for today's dollars from when they bought it, they really didn't have a big gain, but they had to pay a tax on virtually the entire thing minus the value of the land when they bought it, 50 or 60 years ago. So using this for those kind of scenarios is a useful tool. Appreciate your insights very much. And I'm happy to reach out if you have any follow-on questions.
Great.
All
Great.
right. Thank you,
Well,
everyone. Have a
John,
good afternoon.
yeah, thank you, everybody. Thanks for joining us. Have a lovely Thursday. And if any questions, if anyone has any follow-ups for me, you can just throw the my name or the firm's name in Google and reach out to me by phone or email. Happy to help out if there was something that you wanted to ask that you weren't able to. I'd love to facilitate a conversation and get to know you. So really appreciate it, John. Thank you so much for the opportunity.
Likewise. Thank you.